Call the meeting to order in accordance with the Open Public Meetings Act, PL 1975, Chapter 231. Adequate notice of this regular meeting of the Board of Adjustment of the Township of Franklin has been provided. Would you call the roll?
Mr. Betterbid.
Here.
Ms. Graham.
Here.
Mr. Johnson.
Here.
Mr. McCracken. Here. Mr. Rich asked to be excused, as did Mr. Shepard. Mr. Caldwell. Mr. Rosenthal.
Here.
Mr. Reese.
Yeah.
Mr. O'Connell.
Here.
Chairman Thomas.
Here. Resolutions, we have Johnston ZBA 13-00005. Do I hear a
I move
motion?
that.
I second.
Mr. Betterbid.
Yes.
Graham.
Actually, I don't move it.
Mr. Rosenthal.
Yes.
Mr. O'Connell.
Yes.
Chairman Thomas.
Yes. SRI ZBA 13-00006.
I can move that one. Second.
Mr. Betterbid.
Yes.
Mr. McCracken.
Yes.
Mr. Rosenthal.
Yes.
Mr. Reese.
Yep.
Mr. O'Connell.
Yes.
Chairman Thomas.
Yes, and then we have some vouchers. Mr. Bradshaw, August retainer, 865.
I move that.
Second.
All in favor?
Aye.
Aye.
Opposed? All right, Kings Row, with various years of litigation, $5,460. Do we have a motion?
I move it.
Second.
All in favor?
Aye.
Opposed? All right, E&J Equities, $4,425.
I move it.
Second.
Second.
All in favor?
Aye.
Opposed? Okay, those are all carried. And we have an interpretation first on the agenda today, E&J Equities. Mr. Lentz.
Here we go again.
All right, thank you very much, Mr. Chairman, members of the Board of Adjustment, members of the public. My name is Francis P. Linus. My offices are at 21 Clyde Road here in Somerset, New Jersey. I'm pleased to represent E&J Equities tonight. By way of a brief background, the Township adopted a billboard ordinance as a conditional use in the M2 zone at the location at which my client's property is located. The original conditional use ordinance contained an anti-digital provision. That issue went to the Superior Court of New Jersey, and Judge Buxbaum, in late last year, early this year, decided that that portion of the ordinance was unconstitutional, and therefore digital billboards at this location are a conditional use. We then filed an application which is still pending before the Planning Board, and that application is for conditional use approval, for preliminary and final site plan approval, and 2 variances. The application was filed before the Planning Board, and Mr. Dominack, the zoning officer, made a determination that the application is properly before the Planning Board, in that it's a conditional use application, and the 2 variances that were attendant to the conditional use application were not variances that were variances from the conditional use standards. We agree with Mr. Dominack on that interpretation. The reason we're here tonight, in addition to asking the board to affirm that interpretation, that is to say, to affirm that those 2 variances are not conditional use variances, but are variances properly within the jurisdiction of the Planning Board, the additional issue came up during the course of our review of our application. When we took a hard look at the application, it was determined that the lighting standards that are in the conditional use ordinance were tailored specifically for non-digital billboards. And although we believe the digital billboard illumination is much better for the public than the normal illumination from a static billboard, we raised the question to Mr. Dominack whether these departures were conditional use variances and therefore should be sent to the Board of Adjustment. Now, we all want to save time, money, and effort, and we want to get before the right board. So the only issue that we have tonight is what board in Franklin Township will hear and consider this application. And that's why we're here tonight. I submitted a memorandum that I'm sure your attorney has had time to review. The memorandum is dated July 10th, 2013. I'd like to mark that A1. I'm sure the board has copies of it. And I think you need to hear from your zoning officer and your attorney, and then make your decision accordingly.
I've got a couple of questions first.
Sure.
I read the opinion, and in terms of jurisdiction, I happen to agree with your position.
Whoa, that's so far, it's the zoning board's, zoning officer's opinion, which we agree with, yeah.
Okay. Be that as it may, I agree that but however, my question is this. My understanding is that the council has appealed Judge Buxbaum's decision. Is that correct?
That's correct. It's
Okay.
presently in the appellate division, and the township applied for a stay, but the appellate division denied the stay.
Okay. Absent a stay, and I'm looking for hypothetical here. You move forward with conditional use approval, and up goes the billboard, and the appellate division decides against you. Then what?
Then I think the township has every right to ask us to take the billboard down.
And you're running that risk, or you're going to wait pending the outcome, or just, I mean, it's not going to change
As
my
it stand-
opinion, but I'd
right.
like to know
As it
what...
stands today, and again, things could change, my client says, go forward, at their own risk.
Okay,
Where-
you're
where's our
invited to
attorney?
speak.
Mr. Chairman, everything that Mr. Linus has said is correct. I originally issued the opinions that both those two C variances were C variances and could be heard by the planning board, and also the deviation from the lighting standards were not applicable because, as Mr. Linus said in his memo and stated here, they were written, we wrote it, so we know why it was written. They're written specifically for non-digital billboards, so you can't apply a standard for something on a non-digital to a digital. It's just, you can't do that. That's
Why not?
not correct. Because there'd be different standards for a digital billboard. And if you looked at the standards we're talking about, they talk about lighting. Well, there is none of that type of lighting on a digital billboard versus the non-digital billboard. You just can't, you can't apply, you can't say like in football, you don't have to use a bat, because that's baseball. And that's really what we're talking about. We're talking about standards for two completely different things. So it's not applicable. And I know because staff wrote the ordinance, so we know exactly what it was applicable to.
Okay, so, see if I can understand. By the way, where's Mr. Bradshaw tonight?
Mr. Bradshaw's, I'm here. I'm
Standing.
filling in for him. I'm Jennifer, I've been here before for the board. I'm Jennifer Burgess from Mr. Bradshaw's office.
Have you written anything on, have you responded to this in writing?
This was all reviewed. Mr. Bradshaw reviewed it, I reviewed it with him, and we both spoke about it with Vince. So we are familiar with the issue, and we are familiar with the memorandum and the ordinance, and everybody is in agreement with regard to this position.
I emailed Pat Bradshaw, and he told me he was in agreement with it as well, for what
Okay.
it's worth.
Yeah, all the staff, the attorneys, everyone's in agreement. They just want an affirmation from this board to make it crystal clear so that they go before the right board. That's all.
So we're talking two things here. Static billboards, which is the conditions that we're looking at. here.
Well, what you're being asked to affirm two things. You're being asked to affirm my decision, my interpretation, that the two C variances do not rise to the level of a conditional use variance, so the planning board can hear them, and also that the 3 or 4 sections that in regarding to the lighting do not apply for the conditional use standards because they're not applicable to a digital billboard, which means the planning board can hear it. Those are the two things you're asking. The applicant's attorney is asking you to affirm my decision as a zoning officer that the Board of Jurisdiction for the billboard matter is the planning board and not the zoning board. That's the ultimate decision.
So they can't come back here? I think you've collapsed two things. You're talking about a digital billboard versus a static billboard, right?
Well, you're not approving either one. You're only talking about a jurisdictional issue about whether those variances belong before the planning board or the zoning board, which the applicant's attorney, the board attorney, and myself as the zoning officer all believe belong before the planning board.
So they can't come back here at all?
They will not come back here at all. Well, put it this way, at this time, the At this time, the Board of Jurisdiction, based on the current set of facts and the current court that's made a decision, the planning board. If the court makes another decision, there'll be a whole nother round of whatever. But at this current time, based on the court that made the most recent decision, the planning board would have jurisdiction.
And we don't have an ordinance that deals with this lighting situation?
We have a conditional use for billboards,
Which,
that most of the conditional use standards in that apply to both digital and non-digital. The lighting ones were specific, very specific for the non-digital, because digital were not allowed. So we can't apply something that is only supposed to be used against a non-digital to a digital, because they're two separate type of
right.
billboards.
Well, how is it you're collapsing the two of them?
What do you mean collapsing the two of them?
Well, you're using a set of standards for static, and you don't have anything for...
And actually, I understand his concern. Basically, absent a new ordinance, which I don't think the council would be adopting at quite the same time that they were appealing Bucksbaum's decision, there are no lighting standards or a lot of other standards for the digital billboard, because on...
Well, they still have to prove, and Frank, maybe you can explain it better than I used. They still have to.
Yeah, we still have
Yeah.
to prove that the lighting works, and that's a decision by the planning board. So we still have to prove no overglow, no glare, and things of that nature. But to take the cloud away, basically the only difference, and we think the difference is, it's an LED situation, and the illumination comes out. It's in the back of the TV screen, if you will, whereas the static billboard has the lights flashing onto the billboard and then out to the public.
You know, I agree, but I think Bruce's concern is the absence of any lighting standards in our existing ordinance, which there's nothing we can do about.
That's right.
That's for the council, and
Yeah, the council has to write a
council
new...
has to do it.
Right, in essence, the position that I have taken, and Mr. Bradshaw's, and is that the judge has ruled at this point that digital billboards are permitted, because it was improper, this judge says, for us to disallow them. Well, if you take that to the next step, if we have specific standards that don't apply to that, and only apply to, it's not fair to use those standards against them. We'd be kind of going against the opinion.
Well, what's to say that we don't have a set of standards for digital billboards?
We don't.
I know, but there are some out there.
We do not have standards, and they have a right to be heard by a board. And they've made an application, and we've made an interpretation that everybody agrees with, and they'll have to use the ordinance that's in effect at this time, and they will have to prove to the planning board, just like when they provided testimony to this board, that there were certain lighting standards as far as glare and, everything else, that it was not obtrusive to the public or the motorist. They're still going to have to prove that, because that's part of any type of approval for this. They just don't have to prove that they meet or don't meet those three particular lighting standards that are not applicable to a digital billboard. Every other standard in the conditional use, they have to meet, or they'd be before this board.
So Vince, will the council write a new ordinance for digital standards?
I would expect not.
Why would they not do
Well,
that?
because a couple things are going to happen. Either the appellate division is going to say that, yes, they're going to concur with the lower court's decision, and they're going to move forward, and they're going to build it, or they're going to say, no, we win, and maybe they'll appeal that. But the way the ordinance is written, there's only one place that you can have a digital billboard that's permitted at this time. So there is no reason for us to write another ordinance for digital billboards at this time. The planning board hasn't talked about it, the council, there'd be no rationale at this time for us to write new standards.
So they'll wait for the appellate division to make a
Right,
decision?
and even if you did there's an application here now, and we can't, because the application is here and the application is complete, the time of decision rule is completely changed. If the council decided to adopt it now, they wouldn't have to comply with that, because they already have a complete application. So it wouldn't even apply
This
to.
doesn't give us, seems to me that we're talking about something we've already completed. We gave this to the planning board, yes?
You guys, this
We gave
board,
this application to the planning.
this board made a decision. It
So why
issued a
is it back?
statutory denial for it, which was appealed, which a decision was made. We've appealed that decision. They have a right, because the judge said that, struck out part of our ordinance, they have a right, in the interim, at their own risk, to proceed. They've chosen to proceed, and what they're asking tonight is for a determination to confirm what the two attorneys are saying.
Are you asking us to allow them to proceed?
No, I'm asking, alls you're being asked is to confirm my decision as to that these variances do not rise to the level of it having to be heard by the zoning board and should be heard by the planning board. That's all you're being asked
We
tonight.
already decided that.
No,
No, you did not.
Aha.
No, because no one's ever asked that question before.
Well, what did we decide?
Once we denied it,
We
we
denied
denied
it,
the
Bruce.
application.
Yeah.
They went to court.
Yeah.
They won, okay?
Yeah.
Now they have a conditional use application.
Yeah.
Okay, so under ordinary circumstances, if all of the conditions are satisfied, then they would properly, it's a permitted, effectively a permitted use subject to conditions, and they would go before the planning board, which is what their jurisdiction is. Is it-
We got that back again, and we said yes,
No,
to go before the planning board.
we never did. This is the first time. So the issue here
Oh.
is this condition applicable to the, to this application? And since it applies only to static billboards, it's not. So the fact that they don't comply with this condition should not be an impediment to their going before the planning. It's as simple or straightforward as that.
There's no turning down. It's just a decision on what board.
So which board?
This is not a hearing on the application.
Right.
Just tell us what board we're going to go to. Either we
Right.
stay here or we
Yeah,
go to the
what-
planning board.
But I thought we already said,
We
No,
never
we're not-
made
did the
this
planning board
application
ever get
before.
the application?
Now, if we
Did the
decide-
planning board ever get the?
Oh, absolutely. We have a filed application. That's why we're here.
Well, how
Mr.
is it
Dominic
that
told.
it's coming back here?
It's just coming here to decide which board will hear it.
It's
And-
just a verification, it's just we're just
jurisdictional-
confirming Vince's decision, that's all. And we have to do that as a matter of law.
Under the municipal land use law, the first stop in any kind of application is a review by the zoning officer. Your zoning officer has made a determination that this application properly belongs before the planning board. We want to be doubly sure, because of the litigation aspects of this case, that the board is in agreement with that by virtue of an appeal under the municipal land use law and your interpretive powers. So it's your decision.
What's our interpretive power in this one?
You're interpreting...
That it belongs before the planning
Yeah,
board.
you're interpreting that by virtue of reviewing the ordinances, that it belongs to the planning board.
Yeah, I on a daily basis interpret the zoning ordinance. Anyone has the ability to appeal my decision, and that, the first place to go is before this board. If I determine that you made an application and I say that you're not permitted to put a single-family house on your property, and you say, yes, I am, the first place you go here is you ask the zoning board to make a decision whether I was correct or not. And that's what they're doing. In this case, it's a little bit different because everyone agrees. I made a decision, the applicant agrees, the board attorney agrees. All you're being asked is to affirm that decision. Because there's litigation involved, the applicant is trying to be 120% in case there's an appeal later on, that they're going before the right board. They don't want to go before the planning board and someone raise this issue and then have to adjourn that and come back to here 3 months later. That's really what it is.
Okay, everybody clear on that?
Okay, I got it.
You have nothing else, right?
That's it.
Then what do we need, a motion to approve the interpretation?
To affirm my decision.
So moved.
Confirm the decisions of the
Yeah.
zoning officer, both as to the interpretation and as to the
Yep.
appeal
All
decision.
right, we have a motion. Do we
So
have a
moved.
Second.
Any
Mr.
discussion?
Betterbid,
Yes.
Mrs. Gramman,
Yes.
Mr. Johnson,
Yes.
Mr. McCracken.
Yes.
Mr. Rosenthal,
Yes, I hope this is the end of it.
Mr. Reese, Mr. Thomas.
Yes.
Good night, thank you.
Good night.
Good evening.
Oh, that's the fastest hearing you have had.
Okay, the hearing scheduled for tonight, Louis Romero, docket ZBA 13-00014, hardship variance in which applicant is proposing to add a detached single-car garage at 33 Bloomfield Avenue, Somerset, Block 308, Lot 21, in the R10 zone.
Mr. Chairman, just by a little way of background, the applicant bought himself a birthday present, a very new old car, beautiful vehicle, and wants to erect a garage for insurance purposes because unfortunately, his insurance company has to have a permanent structure, not a temporary structure. They want it properly insured. He was scheduled to be here last month. Unfortunately for him, when we reviewed, he had to do a revised survey. When he did that, it was discovered that he had a couple old permits that he needed to fix. He immediately came in the next day, applied for those permits. He had a 20-year-old pool that wasn't finalized. That was finalized. He had put up a new shed in replacement of an old shed years ago. They didn't get it. He's applied for all that. Everything was taken care of. The next day, the board has made it clear to us that you want all that stuff taken care of before they come, so he came in the next day, took care of it. There are three existing variances that need to be taken care of, assuming you approve this. He has a lot frontage, it's supposed to be 100, he's at 95. There's a side yard setback of the shed in the back that's supposed to be 8, it's 5. The rear yard is supposed to be 20, it's 6. The covered portion of the deck that he has is supposed to be 8 foot on the side, it's 2. The one variance that is new is the side yard setback, where it's supposed to be 8, and it's proposed to be at 5 for the new garage. So that's a summary of what's happened in the last couple months on this application.
Okay, is there anything you can add to that?
Hang on one second, though. Please state your name and spell your last name for the record.
My name is Louis Romero, R-O-M-E-R-O.
And, yes.
Is it? Tap it. No, it's not on.
There's 2 buttons, up and up.
Testing, 1,
Yeah.
2.
Okay.
Okay. Thank you, folks.
Hold on one more second. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I certainly do.
Thank you. Okay, now you can proceed.
Sure, my name is Louis Romero, R-O-M-E-R-O, and I reside at 33 Bloomfield Avenue in wonderful Somerset. So, thank you, Vince. A little bit of the story is that I turned 55 in May, and I decided to buy myself a birthday present, thanks to my wife, who approved it, and it's a 1958 Corvette. It is a show car. So when we bought the car,
Full car, man.
the intention was to have it in a covered trailer to take it to shows. Well, the Geico classic car underwriter says you cannot have a show car or a car of that caliber, in a mobile unit, or for transportation purposes, it has to be a permanent structure or a garage. So then we said, okay, let's look at the options that we have, and one of them was to, instead of fabricating and building a whole garage, it would be more cost-effective to have a pre-garage, erected or installed, one that they'll just deliver it. So when we started going through that whole process, I came to Vince and I explained the whole situation, and says, okay, and he was extremely diligent with proposing, all the process procedures, which is totally new to me, because I'm no architect, I'm no engineer, I'm no builder, and I'm certainly not a lawyer. We started with the whole process, and we found out that if we put the garage with the 8-foot side, it would actually put the garage right against the house, and that portion of it would impede on the side door of the kitchen. which actually is another exit and, a fire escape also in case of a fire. So what we need to do is then move it, away from the house. And what we're, actually, the width, the entire width of the garage, of the driveway from the house to property line is 22 feet, all right? And what, the side setback, of course, is 8. That only leaves 14 feet across, so if I were to put that, that leaves only a walkway of 24 inches, which is not really able to open the kitchen door. So what I'm really proposing, the install of the garage is 3 feet, 6 inches away from the side of the house, or from the property line, and that would leave like a 6-foot walkway across inside. And I believe in your package there, there is an illustration of what the garage is.
Can you do me a favor?
Yes?
I did because I was unable to get to your property, but I did do a Google map of your property. And I'd like you to, if you could, and I suppose we can then mark it as an exhibit, mark where your proposed garage is on this.
See that white piece of there? That's my old boat.
Okay. So
The
that's
boat, the
where
boat is
it-
sold, and it was changed for a Corvette.
So it would be there. So have
Correct.
you spoken to your neighbors?
Yes.
And are any of you all neighbors? No. So and neighbors approve?
Oh, yes. I have sent all the certified letters to all 25. I have actually spoken with them. I actually have some signed of the immediate neighbors with their consent.
Okay. Because as I look at this, the garage is pretty far away from the house that's right next door, and I'm perfectly prepared to pass this down. So I don't see that there is any particular zoning harm in terms of where this would be located.
Yeah, actually, you could comply, but I think the variance is a better option.
Yes, I mean, he technically could comply, but then he would have to change the access to his kitchen because they would meet the code requirement. And there may actually be a code issue also with the two structures being closer together. You may have to do some other things to both structures to meet the code, so,
And this meets all the standards and everything for height.
yes,
There's no other, well, otherwise we'd be hearing the variance, I guess.
correct.
Anybody need any more information at this point? We're open to the public. Is there anyone who'd like to make a comment on this? Then we'll close. Do we have enough information from your point of view? All right, we'll entertain a motion.
All right, I move that the variances is set forth in Vince's memorandum, be dated July 19th, 2013, be approved.
Second.
Mr. Betterbid,
Yes.
Mr. Grauman,
Yes.
Mr. Johnson. Yes. Mr. McCracken.
Yes.
Mr. Rosenthal.
Yes.
Mr. Reese.
Yes.
Chairman Thomas.
Yes, good luck with it.
Thank you very much.
30 minutes.
Is there a motion to adjourn?
So moved.
So moved.
All in favor?
Second.